My name is Saul Bienenfeld. I'm a criminal defense attorney here in New York City. I work out of my office in New York City, but I work in all the 5 boroughs as well as Long Island and certain parts of upstate New York. You know, the first sign that you're being pulled over for a drunk driving case, a DWI or a DUI, might be those flashing red and blue lights in your rearview mirror. Or it might just be that you went through a roadblock and the police officer just told you to roll down the window and starts talking to you. Now the question why you were pulled over is very important. You see, you may have been weaving on the street, you may have been taking up multiple lanes, you may have been driving too slowly, you may have been hesitating before going through a green light, and based on a traffic infraction, this police officer has made a determination to pull you over and perhaps just give you a ticket. And as he's talking to you at this point, he's forming an opinion as to whether you may have been drinking or not. He may even ask you, have you had any drinks tonight? And a lot of people answer, yeah, I've had 2 beers. That seems to be the standard answer that I see in most cases. You do not have to answer questions about how much you've been drinking. You do have to give them your driver's license, tell them your name, but you don't have to answer questions about how much you've been drinking. And it's best not to. But you should always be polite to the police officer. Always be polite, never panic, always speak properly and nicely to the police officer. Remember, he's just doing a job. He's pulled over hundreds of people before you. He'll pull over hundreds of people after you. So be polite, cooperate with the police officer. If he sees that you have had bloodshot eyes or watery eyes, or that your speech is slurred, or that your pupils are enlarged, or that you're not speaking properly, he could then make a determination that perhaps you were driving drunk, and he can make an arrest. Now remember one thing, it's very important, that all those things I said, the bloodshot eyes, the slurred speech, the enlarged pupils, the unintelligible speech, all of that could be explained in other ways in your defense. Maybe you were tired, maybe you had fatigue, maybe you wear contact lenses and some dust got into your lens. Maybe you have under extreme stress or you have some other disability. All of that are defenses as to the police officer's opinion as to why he believes that you are driving drunk. Now that he has made a determination that he believes you're driving drunk in his opinion, he then may ask you to get out of the car and do certain field sobriety tests. The one-legged stand. There's another test where he asks you to walk a straight line. He might ask you to touch your finger to your nose while leaning back and having your eyes closed. He's giving you these tests and he's looking at your eyes as well to see if they're moving to determine, if you're making mistakes in balance. If he believes that you're making mistakes in balance and that you're off balance, he might think that you are drunk, and therefore he'll arrest you. Well, now, unfortunately, now comes the handcuffs. He puts you in handcuffs, he puts you in the back of his police car, and he drives you to the police station. At the police station, they may give you the exact same tests he did in the field, only this time they're going to videotape it. They videotape the tests, and that's actually good because now it's not just the police officer's opinion, everyone can see what's happening. So maybe you didn't trip on the videotape. Maybe you tripped outside in the street, but when you got to the police station, you didn't trip. Or you walked a straight line, or you were able to keep your leg up for 20 seconds. So that's a good thing, so that's videotaped. So don't be upset that it's getting videotaped. But after that, they'll give you what's called the breathalyzer test. And this is just a machine to determine your blood alcohol content based on your breath. Now, it's very important that they have observed you for at least 20 minutes before giving you this test to make sure you didn't put anything in your mouth. Because remember, they're testing your breath. If you had just had a drink in your mouth within a minute or even sprayed some mouthwash in your mouth right beforehand, there's alcohol in that mouthwash. There's certainly alcohol in the drink. And the test might be testing that alcohol that's in your mouth alcohol, rather than your breath alcohol. You breathe into the machine, they make a determination based on the average person about how much your blood alcohol content is, and if it's over 0.08, you're going to get arrested and spend a night in jail. At this point, you should definitely try to contact a family member who will then call an attorney. Because if you have an attorney at the arraignment, which is the next step, you'll see a judge within 24 hours hopefully, that attorney, that private attorney, will be able to get you out faster, out of jail faster than a court-appointed attorney. The attorney at arraignment will be making a bail application to make sure you don't spend any more time in jail, and if you have to spend time in jail, that at least a reasonable bail could be posted to get you out of jail, and tell your family members how much the bail is so that they could post it and get you out of jail. You might be offered a plea at this point. Well, it's very important to discuss this plea with a criminal defense attorney who has done this many times in the past, because that plea, it might sound great at arraignment, but if you look at all the paperwork and you determine that maybe there's a problem with this case, that might not be the best plea for you. And the plea might be available in 6 weeks when this case comes back to court. So it might not be in your best interest to take the plea at this point. I see so many clients who have told me, yeah, I was arrested, I just wanted the case over with, so I pled guilty at arraignments. And then they get arrested a second time. And that first case, they always tell me, I really wasn't drunk that first case, but I just wanted it over with. It's a mistake. It's a big mistake to do that, because if you weren't drunk and you wanted it over with and you pled guilty, the second time that you may get arrested, it's a lot worse because you have a prior DWI conviction on your record. So it's very important to analyze whether you should take the plea or not at arraignment, and do that with a criminal defense attorney. After arraignment, hopefully you're out of jail now, you're able to go home, take a shower, relax, meet with your attorney the next day or so, and discuss the strategy. At this time, your attorney should be trying to get as much paperwork and videotapes as he can from the district attorney to go over what transpired that night when you were arrested. You could discuss possible defenses with him and make a determination if any motions need to be made. Motions would be to suppress a statement that you may have made. So when you said, yeah, I had 2 beers, that statement could be suppressed if it wasn't taken properly. Other motions could be made in terms of whether the breathalyzer machine was working properly, whether you were tested 2 hours afterwards, within 2 hours of being pulled over, rather, and if you were tested and making sure that there was nothing in your mouth for 20 minutes. So those are some of the motions that can be made, and the judge makes a decision whether you're getting a hearing on the motion or not. Sometimes he grants the hearing, sometimes he doesn't. If he grants the hearing, that's great, because now your attorney has an opportunity to cross-examine the police officer, to ask him questions, to get a feel for how the trial would be going. Assuming that you're still going to trial, of course, trial starts with an opening statement by the prosecution. Then your attorney may or may not make an opening statement. The prosecution then puts on their case, usually just police witnesses. The prosecution rests. Your attorney, of course, had an opportunity to cross-examine these witnesses, and then you can put on your own case. Afterwards, the case goes to the jury. The jury will then decide whether you're innocent or guilty or not guilty. If they come back not guilty, that's great. You go home. You're very happy, and if you're found guilty, it goes to the sentencing phase. And this is where it's very important to have a very good criminal defense attorney on your side, because a good criminal defense attorney may be able to convince this judge, even after trial, that you should not go to jail. That although you've been convicted of a crime, perhaps probation would be best suited for you. And it's important for a criminal defense attorney to put together a pre-sentencing package to show the judge that there's no reason to put you in jail. There's no reason to incarcerate you. It won't be serving anyone's justice, anyone's purpose, and that they should keep you out of jail and a member of society. There could be a possibility of an appeal afterwards if there was a problem during the trial. And again, you should consult with an attorney to read over the record to determine if there is any chance of an appeal. That is how a DWI case goes from the start of when you're pulled over all the way to the end of a trial, but at every phase you need to be consulting with a criminal defense attorney who specializes in drunk driving. Here at the law offices of Saul Bienenfeld, we do specialize in DWI cases. I welcome your call if you want to call me at 212-363-7701, or you could go to my website and determine if we should get together and discuss your case. Consultation is free. Good luck to you no matter what you do, and I hope that if we do meet, it will be under wonderful circumstances. So good luck to you and take care. Thanks so much for watching.